right. Good evening, everybody. Thanks for joining us tonight on this beautiful evening. Tonight, we are going to learn about protecting your property rights for the future with Eva Adams from the Center for Disability and Elder Law. I'm Carla Bruni, Chicago Bungalow Association's Preservation and Sustainability Specialist. Just a reminder on how we run these. We're going to be recording this tonight, so no worries if you miss something and are frantically trying to scribble everything down or freaking out when you're trying to get your question in at the end that you think maybe came up earlier. We're going to be sending this out to everybody who registered tonight, so you're going to get an email. Sometime within the next several days, it's going to go out with a link directly to this webinar. Beyond that, you can find all of our webinars. So we've been doing this ever since the pandemic started. You can go on our website at chicagobungalow.org and go back through all of our archives and find all kinds of great stuff. So make sure you take advantage of that as well. Eva's going to be talking for about 40 minutes or so tonight. We're going to do questions at the end. So you'll notice at the bottom of the screen, we've got a Q&A button down there. Don't put things in the chat because it's actually disabled. We won't be able to see them. So go to the Q&A section and the little question mark in the box and make sure that you put any questions that pop up along the way in there. A lot of them are probably going to be answered. I've seen this before as we go too. So you might want to hang tight a little bit, but that's where you're going to put whatever you need to put. So we're going to have a hard stop at 7 p.m. tonight. So we'll get through as many questions as we can. I know Eva's also going to have a QR code at the end and other ways you can contact CDEL if you need to afterwards. Chicago Bungalow Association also has more webinars coming up in the future. So check out our website, again, chicagobungalow.org, and we'll have a list of things there and our programming. It's also our 25-year anniversary this year. So we've got all kinds of new and exciting things we're going to be throwing out there at you guys in different neighborhoods. So check back on our site for that as well. Okay, so protecting our property for the future. This is about knowing what will happen to your home after you're gone. Have you made plans to ensure your beneficiaries will become the legal owners? Eva Adams, attorney with the Center for Disability and Elder Law, is going to discuss estate planning and different ways to transfer property after you pass away, what you need to know about property fraud, and more. This is a big issue with a lot of our members, so we really love having this webinar. A lot of times people think that they've transferred things down to their next of kin, and they haven't actually officially done that. So just a little bit about Eva. Eva Adams is a staff attorney at the Center for Disability and Elder Law, known as CDEL. She heads up the organization's Housing Preservation Program, the HPP, which focuses on the desire of senior individuals to age in place and more broadly on a family's home as a source of generational wealth. Specifically, she provides information about the benefits of individuals being on title and information regarding transfer on death instruments, or TODIs, which adds a beneficiary to the home and allows that asset to bypass probate proceedings. HPP provides legal assistance to cost-burdened senior homeowners with issues including title correction, property tax matters, foreclosure and building code violation defense, and succession planning. Additionally, HPP hosts a bi-weekly legal help desk at the Cook County Clerk's Office that seeks to help qualified candidates draft documents, claim property tax exemptions, and provide advice about complex property issues. Ultimately, HPP aims to provide education so that a home or the equity from that home can remain in the family and in the community. All right, well, thank you so much for joining us tonight, Eva. I'll let you jump in whenever you're ready with your presentation and we can get going.
Sounds great. Thank you for the introduction.
Sure.
Let me get my screen shared. All right, and you should be seeing that now. Just real quick, I want to caveat, I'm an attorney. I'm not your attorney. And by that, I just mean this is a presentation for informational purposes only. Nothing here is meant to be individual legal advice. We always recommend consulting an attorney for any legal issue you may have. I am with the Center for Disability and Elder Law, and today we're talking about protecting your property for the future. Give me 1 second. All right, so a little bit of history. The Center for Disability and Elder Law is a nonprofit organization. We were founded in 1984. That means we've been around for over 40 years. We were established in response to a study that found that 100% of those living in poverty will experience at least one legal issue, while 80% of those same individuals will be unable to obtain legal representation. Um, so for more than 40 years, we've been helping that demographic. Our mission statement is to provide quality, free legal services to low-income seniors and persons with disabilities within Cook County and Chicago. But I like to focus also on number two. We like to foster the spirit of pro bono service by partnering with volunteer attorneys throughout the Chicago legal community, so that we can continue providing high quality legal assistance to our demographics. In 2024, CEDL closed over 2,800 files. Is a little higher in 2023, but that's only because my position wasn't there. So we have several practice areas. Today we're touching on estate and end-of-life planning, but also housing and other real property issues. But that's not to underscore, we do a lot of adult guardianship of the person. We do simple divorce work, and we do some collection and consumer debt through the early resolution program through the court system. We have a lot of programs. We have 11 well, I need to fix this slide. We have 11 community clinics on the south and southwest sides of Chicago. We do power of attorney workshops, which include an education component, and then going back to that same location to draft documents. We have a help desk for guardianship in the Daily Center. I have my help desk at the clerk's office. And everything that Carla just talked about is something that we focus in that housing preservation program. So our eligibility, typically when you're seeking services from us, you are a resident of Cook County, you are a person over the age of 60 or living with a permanent disability. We do prioritize low or low moderate income. That's not a red line in the sand. We do like to look at the whole person and their ability to pay. And then it has to be a legal issue within our practice areas. So it has to be estate planning, divorce, a property matter. It has to be something that we practice in. If you were to call me and say, hey, I have a medical malpractice case, I need to sue my doctor, I would tell you you need to find an attorney. So the question of all of this tonight is, why is planning for my home important? Often it's the people who've experienced the probate court and the probate process with another family member who are seeking ways to avoid doing it again. Um, as an attorney, I hear all of the bad stories. Sometimes things work out perfectly and your family gets along and everything's great. Sometimes they don't. So it's important to be on title to the property. So if you or your heirs are not on title to the property, you or they cannot refinance the mortgage to avoid foreclosure if that's necessary, draw from the equity to make needed repairs, or pay back taxes. And when I say needed repairs, I'm not talking about the toilets leaking. I'm talking about, the porch falling off, the roof is caving in, or like plumbing is just not coming into the house. There's a major issue. You're not able to claim property tax exemptions to which you're entitled. So specifically like the senior exemption, you wouldn't be able to claim that if you're not on title. And then even if you wanted to like step away from those issues, you couldn't sell the home without being on title. So if you don't plan ahead for your home, your heirs will have to go to the probate court upon your passing. But we want to avoid that. And so that's why I'm here to talk about the transfer on death instrument, or we always call them a TODI where I am. You could also hear this called like a TOD or a transfer on death, anything. They exist in other states as well. It's a short form created by the Illinois statute, and it's recorded with the Cook County Clerk's Office Recordings Division. It costs $59 to record, so it's a one-time fee. It's not like recording a deed where you have to have your full payment certificate and pay any transfer taxes. It's a solid flat rate $59. The catch is it has to be recorded before the homeowner passes away. Essentially, this document is going to make your house like a payable on death account. It's going to name a beneficiary or multiple beneficiaries to receive your home after you pass away. It generally will avoid probate for the home, and it's revocable. So if you change your mind, you can simply record a new TODI or a revocation document, as long as you have the mental capacity to do so and to pay another one-time recording fee. So I've said probate a lot, right? But what is probate? Probate is the process through which the court supervises the distribution of certain assets of the decedent or the person who passed away. And so what happens in probate court? Generally, the court chooses someone who's going to oversee paying the decedent's debts and distributing their assets to whoever is inheriting them. So that would be like the beneficiary or the heir. Um, and this is a little technical, but when the court appoints someone, that's the administrator. Um, if somebody named somebody to do this in their will, they're called an executor. It's the same job. So why is probate so expensive and time consuming? A quick estate in the probate court is administered in about 6 months, and that's fast. The administrator or the executor usually has to post a bond, and that's 1.5 to 2 times the amount of the personal estate. It's kind of like an insurance policy. In Cook County specifically, bond companies usually will not issue a bond like this without an attorney. So you're almost guaranteed to have to hire somebody to get you through this process. So when is it necessary? Probate is required in these instances. So if the decedent has more than $100,000 in assets, if they owned any real property, so like a home, if there's any fighting among family members over who is entitled to what, if there's any unpaid or unknown debts, or any allegations of undue influence, that classic example of you had mom sign this document when she didn't know what was going on. Those are all ways to end up in probate court. Most common is going to be having over $100,000 in assets or owning a home, that puts you immediately in probate court. Generally, with the clients that I work with, all of their money is in their home. That's all of their assets. That's all equity in their home. It's their largest asset. So in order to avoid probate, what we're doing is we are naming a beneficiary. We're doing a transfer on death instrument. It removes the house from that probate estate. Um, and as long as the person has less than $100,000 in assets, they can do a small estate affidavit. Um, so that reduces the estate to such an amount that you can do this affidavit and just completely avoid probate court, provided there's no dispute among family members or unpaid or unknown debts or that undue influence. So when we count up that $100,000, what's included? That's going to be anything without a beneficiary. So, thinking about it, Tody, it's a time to start thinking about an entire estate plan. Is there a beneficiary attached to your checking and savings accounts? Um, you can do an affidavit for your vehicle. It's free with the Secretary of State. You want to name a beneficiary on as many items as you can so that they don't contribute to that $100,000 limit. What is going to be excluded? Well, naming a beneficiary. So your life insurance policies, your IRAs, those you kind of have to have a beneficiary listed. But what's not mentioned is anything you own jointly. So if you own your home as joint tenants or as tenancy by the entirety, as is the case between husband and wife, those automatically have a beneficiary in mind. The first to pass away is leaving that to the survivor. The survivor takes the entire portion whenever you own something in these ways. I went backwards, but we're going forwards here. So a big question is, I have a will, and doesn't this avoid probate? No. So having a will by itself, it's a great step. It's a great step towards having a full estate plan, but on its own, it's not going to avoid the probate court. It will make probate a little easier because the court doesn't have to determine who gets what. The will is going to guide the court in making that process easier. It's going to say, Aunt Josephine left this, and to her 3 children, they take equally. But if you pass away without a will, Illinois law, otherwise known as the Illinois Intestate Succession Act, will decide who gets what. There's a plan in place. It might not be the plan you want, but it's the plan that Illinois is going to impose. So I do not have a will. So does the state of Illinois take my property? No. So if you pass away without a will, Illinois law will decide who gets what. That doesn't necessarily mean Illinois is going to take it from you. It's only if no kin can be found does your land go or your home go to the county. Everything else would go to the state of Illinois. This is an extreme example. You would have to have no family or next of kin for this to happen. It's very rare. So when we're talking about removing that home from probate, so often it's somebody's largest asset, there's several ways you can do it. Often we come across quitclaim deeds where you add somebody as a co-owner. It works, but maybe it's not the best tool. We have that transfer on death instrument. You can also complete this type of estate planning with a trust. Just a caveat, CEDL itself does not draft trusts. There is no legal aid organization right now that drafts trusts. If you want a trust and you want to explore that option, you will need to consult a private attorney. So this is a just graph of kind of comparing that quitclaim deed with that transfer on death instrument. So when you add somebody with a quitclaim deed, you're adding them as a co-owner in the moment, right away. So who's going to own that house? It's going to be you and the person that you add with that quitclaim deed. When you record a quitclaim deed, that is going to be $107 plus any required municipal fees. And these fees can include that full payment certificate. Water runs with the land. You have to have your water bill paid off in order to record a deed. And that's just in the city of Chicago. Some townships around Chicago, around the Chicagoland area, have additional requirements, additional fees. There's one that comes to mind where even if it's a quitclaim deed from yourself to yourself with somebody else, you're not actually selling to a third party. They want you to get your house inspected. So it could be anything depending on what township you're in. So with a quitclaim deed, that happens immediately. The moment you execute that deed, it is valid. As long as it is signed and delivered, it is valid. It doesn't have to be recorded. That goes to notice. I mean, obviously you need to record every deed, but it is valid. It happens immediately. So comparing those to the toady, adding somebody, you're adding a beneficiary. You are the owner during your life. That beneficiary only has an interest that they can take when you pass away. It's $59. That's a far cry from 107 plus fees. Um, and then when it comes to this, when it's transferred, it's not until after you pass away. That's a big difference. Um, this comes up a couple cells later, but if somebody's a co-owner with you and they have debt, their debt is that your house is their house for that debt. So you don't always have like protection when you have somebody on your deed as a joint owner. Um, if you change your mind after you've already added somebody with a quitclaim deed, you can't change your mind unless they agree with you. They have interest in that house. If you want to do a new deed, you're going to need their permission. Um, Again, with the toady, it's revocable. You can do it yourself. And a big question that comes up is, well, what if I want to sell my house? Do I need to? You don't do anything. If you don't own the home, the toady is inactive, so there's already a new owner. But if you do want to revoke it, you just do a new one. It's $59, which don't get me wrong, $59, it's real money, but it's a lot less than you could be paying using a different tool. A quitclaim deed doesn't offer any protection against creditors for joint owners. If somebody has debt, they go to court, they get a judgment lien put against their asset. Well, their asset is your house if you are both owning that house. It doesn't have to be your debt. That asset is not protected. With the toady, your beneficiary, if your beneficiary has no debts, there will be no impact on your home during your lifetime. Or if your beneficiary has debts, there will be no impact. And that's really important. They do not own the home with that toady. They only own it after you pass away. I like a good Google read of dollar signs. So I mean, in the world, a trust would have a couple more dollar signs attached to it. But when it comes to expenses, a quitclaim deed can be $2 to $3 dollar signs in this pictorial. A transfer on death instrument it's the cheapest option out there. And do you need your lender's permission? Often we don't buy our homes outright. We have a mortgage, right? To add somebody to your mortgage, you will generally have to refinance. So in that sense, you will need the lender's permission to add somebody with a quitclaim deed. When it comes to a toady, because you're not adding somebody during your lifetime, you don't need your lender's permission. What will happen is when you pass away, they can take that acceptance of toady, which we're going to talk about, and they can call the mortgager and say, you know, I have an interest in this home now. You need to work with me. Um, you don't need permission from your mortgager to add a beneficiary. So who can do a toady? I've talked about what it is and like how it works and how it's different than other tools. Only the homeowner, the homeowners or the homeowner, like if there's one. In other words, you cannot do a toady for someone else. Even if you're their power of attorney, you can't do one for someone else. So daughter cannot call and do one on behalf of dad. Brother cannot call on behalf of sister. You can't do one on behalf of your siblings, child, grandparents. It has to be the homeowner driving the bus. And that's a deviation, especially if you're the power of attorney for property. Often you can do property transactions. You can, depending on how it's drafted, you can buy and sell property. You can, lease property for the principal. You can't do a toady on their behalf. I just like to reiterate, you just can't really sign somebody up for legal services. They have to want them. The homeowner has to want to do the toady, and they have to have the mental capacity to do the toady. Um, so I like to say that mental capacity, nobody can drag somebody in front of an attorney and just say like, do this for them. And they don't know what's going on. We have to assess that this person wants this document. So what happens after I pass away? I've done a toady. You talked me into it. I did one. What happens when I'm not here? So your beneficiary would record a notice of death and acceptance of toady and attach your death certificate. That would be $107 to record. And your beneficiaries would want to decide if they want to assume the mortgage. They'd have to call the mortgager and obtain title. Or say the property's underwater, or you had a reverse mortgage, or any number of reasons they don't want that property, they are able to disclaim it. You in the law, you can't really make somebody accept a gift. And so they do have that out. However, especially in this economy, I always kind of think of you'd want the house 9 times out of 10. You want the house as opposed to getting rid of it. But there are reasons to disclaim. Um, but by doing a toady, your beneficiaries, whether they take the property or not, are able to bypass the probate court in order to obtain title, which is so crucial and so important. Um, and so this toady, it sits within a comprehensive estate plan. And I call it a comprehensive estate plan because it's not just about what happens after you pass away. You want When you're looking at these documents, you would like to look at a power of attorney for healthcare. So that's going to encompass like how do you want your family, your loved ones to treat you when you can't make decisions for yourself? Including that living will declaration that we can draft with that document. It hinges on whether the quality of your life is more important than the quantity of your life. So it's talking about that end of life death delaying procedure, whether you're for it or against it. Those are really important. When it comes to finances and property, we have the power of attorney for property. That allows somebody to access your bank accounts, to pay the mortgage, to pay credit card debt, to do those financial transactions on your behalf when you don't have capacity to do so. And so we've talked about those like estate planning documents during life. The moment of death is when you would want something to transfer your home out of your probate estate. You would want to add beneficiaries to any accounts that you may have. And then after you've passed away, that's where your last will and testament would essentially, for a small estate, so one under $100,000, that would divide your personal assets. So your tea towels, your cutlery, your plates, your bedding, things like that within the house that maybe aren't high value, but have a lot of sentimental value. And because we're talking about the home, I really always like to let people know about this fraud protection unit at the Cook County Clerk's office. I encourage everyone to sign up for this. The way that this works is if somebody records a deed or any type of conveyance against your property, you're going to get an alert if you sign up for this program. So they will call you, they will email you, and they will alert you that something is going on with your property. And that's great because if it wasn't you recording that document, you can catch that quickly, and the in-house counsel at the clerk's office will help you figure that out. I really highly recommend finding this website right here. You can also look up the fraud unit at the clerk's office online. And then holistic approach here, we want to look at opportunities for savings, specifically with your property taxes. I know the South and Southwest sides are getting hammered with them right now. You always want to be collecting that homeowner's exemption. If you are a homeowner and you're living in the home, you want to collect that exemption. You can't collect it at more than one home. It has to be your home. That's going to automatically renew every year. The senior exemption. If you're 65 or older, you're going to want to claim this exemption. Again, it's automatic. You're not going to get any younger. At least I haven't figured it out yet. And that's going to renew every year. The senior freeze exemption is going to freeze the assessed value of your property. You have to be 65 and older, and your annual income has to be less than $65,000. This one does not automatically renew because, in theory, your income will fluctuate. Of course, that may not be true if you're a senior living on a fixed income, but the idea is that you could have more income one year than the next. And then there's the persons with disabilities exemption, the returning vets exemption, and they've recently expanded this one, so it has a little more depth and it encompasses a few more people. Okay, but maybe this was the first time you heard about those property tax exemptions. Maybe you haven't been collecting them. You're like, oh, wait, can I get them now? You can. You would look online. You can file what are called certificates of error. They are typically tied to the annual property tax sale, but COVID messed that up a little bit. At this time, you can actually go 5 years in hindsight to collect property tax exemptions. So that means if you haven't been collecting your homeowner exemption for the past 5 years since tax year 2019, you can go online and you can maybe recoup a couple bucks of overpaid taxes. There's a couple other opportunities for savings when it comes to utilities. The senior citizen sewer exemption, you're going to have to apply for that through the city. The senior citizen garbage fee discount, that's going to apply automatically if you're receiving that senior freeze exemption, but you can also apply for that. And then there's LIHEAP. I think this is the most common one that everybody knows about, but there's home energy assistance for those who qualify. I know I started out with this information. I said that there's no one size fits all solution. I'm an attorney, but maybe I'm not your attorney. This is really all information. And the reason I have that help desk is because sometimes a legal issue when it comes to your property is often the symptom of the root cause. And I say it that way because property issues can become insidious. So just because I said something today, maybe it doesn't apply to you. Maybe it applies in a different way. Maybe there's an exception. Talking to an attorney is the best way to figure out which option is best for your unique situation. No two people have the same legal issue. And I know we saved a lot of time for questions. I tend to breeze through this one because I like helping you. I like hearing your questions and answering those live. Sometimes I think that's the best way to learn about information. Um, I do want to just point out, I'm going to leave this screen up for a bit. This is a QR code. So if you heard something today and you want CEDL to reach out to you, if you want CEDL to call you and talk to you more about this TOTI or how to do it, scan this, fill out that. I just want to reiterate, CEDL doesn't guarantee legal services to anybody. So we're going to guarantee you a phone call. And that's when we will decide if we're able to assist and what your next steps may look like. Do not worry about putting information in. by putting information into this form, you are soliciting us to call you for legal services, and that is a confidential moment. So none of that information is shared with anyone except myself and the people in my office. We will not call you except for this limited circumstance. And if you heard this presentation, whether it's live or through a recording, and you want to call, you want to sign somebody else up for services, go ahead and give them that phone number, 312-376-1880. This number is really important. It's our main line number. And even though I told you about what CEDL does, I like to think of this number as like the starting point to finding legal help. Say you have an issue, you don't know where to start, you don't know how to find an attorney, maybe it's not something CEDL can help with. And if that's the case, we're going to send you a tailored referral. And by tailored, I mean it's going to have several phone numbers that you can call that will get you going on a legal path in which you can find assistance rather than going it alone with Google. So do call this number, share this number. It's meant to be a resource, okay? And then with that, I'm going to leave this screen. Carla, did you have any questions?
Yeah, thank you so much, Eva. So much good information in there. You guys, we love working with CDEL. You're like so accessible and so helpful to our members. So thank you again for all of that. We do have just a couple of questions, actually. Apparently, you did too good of a job getting through things. So we'll see if other people sort of sometimes in a panic, people push them in at the very end. So.
That's
Um,
okay. I'm here to answer questions. They're my favorite part.
Excellent. So in terms, somebody had asked where to get a particular form that you had put up. I'm not sure exactly which form that was. It wasn't specified in the questions, but Cheryl had posted below it, there's a link that she posted that should take everybody to the forms. If you have anything else to say about where to acquire them or the best way to get them or something, feel free, Eva. But just want to make sure those are clearly important. Um, then somebody asked, what if I have a toady with my son on it, but married later? Who would get her house?
So we like that question. So even you can't completely cut out a spouse. There's called the spousal renunciation or an elective share. So within 7 months of you passing away, your spouse could petition for part of your property. Um, so really we would want to assess here, are you intentionally cutting out your spouse? Or are you wanting to share it? We would need to ask a couple more questions, but that is the general advice we give is in Illinois, you cannot intentionally disinherit your spouse because they can petition the court for that share.
Okay, interesting. If you have a land trust and a will, does this avoid probate?
Yeah, so trusts are phenomenal documents, and there's so many of them. That land trust, if I'm understanding, those are going to cost a little bit of money every year to keep them active. So if you have a will and you have that land trust, when you pass away, as provided that there's provisions for your property will transfer by that land trust. As long as you have less than $100,000 of other assets, that should keep you out of probate. That will be able to be administered for small things around the house. So those would work together to keep you out of probate. Again, provided that you have less than $100,000 worth of assets and that there's no infighting within the family.
Okay. Do you have a booklet with all of this information? Is there a hard copy?
Um, Sometimes I do have an FAQ sheet that I would love to share with the Chicago Bungalow Association if you'd like
Great,
to
yeah.
include that.
Mhm.
Otherwise, this slide deck, I believe, will be shared in the video.
Okay, great. And again, anybody who signed up tonight's going to be getting a follow-up email where we'll have all of that information. We can include the form as well if you could just send it to us, Eva. So you'll be able to look at all of it again.
Um,
Oh, sorry, go ahead.
oh no, I was reading, I see another question because I did pull it up. So where do I fill out a TOTI? There are some phenomenal online resources. If you contact CEDL and you are a senior or a person with disabilities, we will assess to see if you qualify for us to do that document. But I can always send self-help resources for someone who doesn't qualify.
Great. And how long does the family have to file the TODI after a death?
Yes. So I know that the clerk's office has done a presentation in which they say, I think 3 years. That's technically not in the statute. You would want to file that acceptance of TODI fairly quickly after death, especially if there's a mortgage on the property, or if for any reason there's like delinquent taxes or anything like that. Those are reasons you would want to do it very quickly. But even without those like pressures, you might still want to record it quickly because those pressures can add up year on year. So maybe there's no delinquent taxes when mom passes away, but nobody's been paying them and we've been arguing over the property for 3 years. So like you want to avoid any of those issues. You want to make sure if there's a mortgage, the payments are being made. You want to make sure property taxes are being paid. So really, even though 3 years isn't in the statute, I would say definitely you'd want to still do it within that time frame.
Okay. My spouse passed away, but the property taxes are under his name. What do I need to do? That's a little out of scope, but yeah.
No, I got you.
Great.
So, if it depends on how, I mean, lawyer answer, it depends. But if it's just that the property taxes are in his name, anyone can pay the property taxes. So it doesn't necessarily matter whose name is on that property tax bill. What really matters is whose names are on the deed. So if you are both listed as co-owners, phenomenal. You can just go and change the property tax bill to reflect your name. That's easy. It's online. If you're not on title, that's where things might get a little more difficult and you would want to seek legal counsel.
Okay. So I should call you guys. Got it. Uh, what if you have more than 100K? This is sort of a follow-up, I think, to an earlier question. But if you have more than 100K, but have beneficiaries on most every asset, this is in addition to the land trust and will.
Yeah. So this question is great because that's the crux of kind of creating this type of estate plan. So if you have beneficiaries on all of those assets, they don't count towards that $100,000 limit. And then I see your follow-up. So to the land trust and the will. So you have the land trust, the will, beneficiaries on all accounts. You ideally would bypass probate. That's the point. You want beneficiaries everywhere. To get that number under $100,000, your land trust takes care of your property. The will for those personal assets that aren't going to count towards that number, but at least in my family, there's a lamp. I want the lamp. So that's why the will is going to come into play. So that is exactly what you want to be doing.
Great. Okay. Who gets my house if my beneficiary declines it?
That's an excellent question. So in this document, we list a beneficiary, right? And then we list a successor beneficiary, because maybe your beneficiary declined it. Maybe the beneficiary predeceased you. I know it's not the natural order for children to pass away before their parents, or for your spouse to pass away before you. But I'm an attorney. We plan for those eventualities. We plan for those things that you don't want to think about. So we would list a successor beneficiary in that regard. I'm trying to think if no beneficiary is alive to take that property or no beneficiary wants that property, I would have to research that question.
Okay. These are a little bit tied, the next two. Say that we have no mortgage. Can I still have my children stay with the house?
What do I would need a follow-up to be like, oh, how do you get the title? Mortgage is paid off,
Yeah,
where
there's
slash
different
how do you get the
different
title?
people, but I
Um,
wonder if
Yeah, you don't have to
okay.
have a mortgage in order to do a TODI. It's just really common for people to have a mortgage that I like to include that information. But there are just a phenomenal amount of people who have their homes paid off, which is amazing. And that just means that your children would have one less step whenever I assume children, but that means your beneficiaries would have one less step when it comes to accepting that property. I hope I answered the question, but I didn't quite understand it.
Yeah, it was a little bit unclear. I know sometimes people want to jump in like it's a conversation. And that's the bad part of a webinar, unfortunately. If the mortgage is paid off, where and how do you get the title?
So actually in Illinois, this kind of comes back to legal theory, but in Illinois, you own the property subject to the mortgage. So you own the property and you have the mortgage. You are the owner. So the title is going to come from the names on the deed. And this is different to other states where you only own the property after you pay the mortgage. Here you own the house. You are on title based on what the deed says. Of course, the mortgage has to be paid, but it's based on those names on the deed. Yes, the question.
That was the
Oh,
earlier one. That I
oh,
think we guessed
thank
on, so I
you.
think we got it right. I think that means we got
Okay,
it
good.
right. You got it right, I should say. Um, okay, that's the last of the questions then. I think we covered everything. Thank you so much. And again, if anybody thinks of things going forward, we've got this QR code. We're sending all this out in emails. It's a beautiful evening. It's a full moon tonight. I hope some of you have plans to watch the full moon if possible. And thank you, Eva, so much. This is really great. We really appreciate all your knowledge, and all your help.
No, thanks for having me. And I just want to plug one more time if asking a question in this type of format wasn't um something that you wanted to do, if you have a question you didn't want to share with the group, please do use the QR code, call our pre-screen line. It's a good place to start the process of getting an answer. I see one person asked another question. Yes, we'll answer and we'll give our best answer to any question you send. Use the QR code, call that number. We're answering everything. Quick caveat on the phone number, leave a voicemail. Even if you don't, we're going to see every number that came through on that line and we're going to return the call. I do want to let you know it could be about 2 weeks. That is our like timeline. But we will be answering. If you need immediate assistance, there are other legal aid organizations that provide that. Thanks, Valerie.
All right, great. And Maria.
And
All
Maria.
right. All right. Thanks again, Eva. Really appreciate you. And we will see you in Sea Dell soon, I hope.
Y'all have a great night.
Thanks, you too.